The indictment of President Trump and the assignment of Judge Juan Marchand to preside over this case, the same judge who's presided over all the other anti-Trump cases, and apparently whose daughter works for a bunch of Democrats, so it's alleged, has reminded me of a story involving our Second Amendment rights and the gun industry and attempts by the anti-gunners to drive it out of business and take away our rights going all the way back to the 1990s. Let's talk about this story that very few people know about and even fewer people probably remember, but I know it all. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner channel, please do so. Show your love for the Four Boxes of American Liberty and Frederick Douglass. Okay, folks, so I don't do a lot of talking about the Donald Trump case. I'm not going to do it here either, but I am going to use it as my launching off point to talk about what happened in the 1990s and what ultimately resulted in a very favorable win for the Second Amendment. It's one of these geeky historical stories that very few people know about and very few people remember. So we're going to give you that information so you become, again, the smartest person in the room when it comes to our right to keep and bear arms. Okay, this week, as you know, President Trump was indicted. We all know this. That case was assigned to Judge Juan Marchand, who is a criminal judge in New York State. Allegedly, his daughter had worked for or works for various companies that help out Democratic politicians, from Kamala Harris to Adam Schiff, and so on and so on and so on. I don't know if it's true or not, but that's what I'm reading. So that gave rise to the question of how is it that Judge Marchand keeps getting all these anti-Trump cases when his daughter is connected to all these Democrats? How does this keep happening? Well, I don't know all the specifics of there, and that's not what I want to talk about today. What I want to talk about is another situation back in the 1990s involving the assignment of judges and how important the assignment of judges and the process for assigning judges became when it came to our rights in the 1990s and even up to today. So let's go back into the Wayback Machine. For those of you who may not remember, in the 1990s, this was before, for example, the Supreme Court had decided the Heller case, which of course is in 2008. In the 1990s, this was before the election of George W. Bush. In the 1990s, this was actually for a large part before the internet became ubiquitous. In the 1990s, this is when Al Gore wore brown suits and was the vice president, and before he lost that 2000 presidential election to George W. Bush, with Florida weighing in the balance. So with that setup, what was also going on in the late 1990s? President Bill Clinton was in the White House. Andrew Cuomo was the head of HUD. And what was going on in the late 1990s was an attack, a robust attack on our gun rights and our Second Amendment rights. If you remember, in 1994, right before the midterm elections, Bill Clinton signed into law the assault weapon ban with the support of, anti-gun liberal Democrats, as well as a bunch of quote-unquote law and order conservatives who I'm happy to report are largely gone now, thank God. But set that issue aside. So here we are in the late 1990s, and a new strategy is developed in the second part of the Clinton administration by people like Andrew Cuomo. And the answer is sue until you destroy the gun industry by imposing cost on the gun industry. Now, bear in mind that you cannot realistically sue people for conduct they have no control over. So the gun industry obviously doesn't interact with gangbangers, so they sell a gun into the lawful chain of command. This is the case in the 1990s and was ultimately, sold through FFLs and whatnot. And eventually some of the guns that they manufactured down the line, many times decades later, would get into the hands of gangbangers and other street criminals, and these people would commit crimes using those guns. No different than presumably, street gang members would use baseball bats made by baseball bat companies to commit crimes, and VCR makers would, make VCRs that would ultimately be used with illegal pornography, for example, by people. But none of this meant that the manufacturers were ultimately responsible for these crimes, over whom they had no control, didn't know these people, and they were just misusing these products. Nevertheless, in the late 1990s, there was an attempt to destroy the gun industry and force gun control on the industry by basically bringing them to their financial knees. So you saw a whole bunch of lawsuits brought in places like New Orleans and other places, Chicago, to try to impose cost on the gun industry because the more they spent on lawyers and insurance and time and resources devoted to these lawsuits, which were basically legally frivolous in my view, nevertheless, you still have to spend time and money to defend them. And of course, the granddaddy of them all, in my view, is a lawsuit filed, or a series of lawsuits filed in various ways, in the United States District Court for the Eastern District of New York. Specifically, there was a series of lawsuits brought against the gun industry by plaintiffs' lawyers in 1995 or so. And here is where the Trump connection comes. When a lawsuit is filed in a courthouse, most courthouses have multiple judges. So when a lawsuit is filed, the question becomes, what judge gets the case? Now, there is a random selection that takes place. A person brings a lawsuit in a courthouse. It is randomly assigned, could be a spin of the wheel, could be the drawing of lots, it doesn't matter. There's a random process of the assignment of these judges when a lawsuit comes into the courthouse. Now, there is an exception. There's an exception to the random spin of the wheel, and you're going to see why this is so important and how the anti-gun movement, in my view, tried to exploit this procedural process to their advantage and actually, in my view, succeeded. So when a lawsuit or criminal case is commenced, it's commenced in the clerk's office. Now, the clerks are basically a group of administrators who handle the paperwork and keep the files in order. So what happens is you bring the lawsuit or criminal case in the clerk's office. The clerk is the one responsible for doing the assignment through the randomness of the judge. Now, if you write on your piece of paper that there is already pending in the courthouse a related case, then that clerk will automatically assign your case, your new lawsuit, to that related matter and to the judge who's handling that prior related matter automatically at the first step. Then your lawsuit, your piece of paper that describes your case, is automatically sent by the clerk's office to the judge presiding over the alleged related case. And then what happens at that point is the judge looks at the new document, the new case, and he reads it, or she reads it. And then the judge who has the prior case that allegedly is related to your case, the judge will look at the documents and will make a decision independently of whether or not that case that you just brought is in fact, in the judge's opinion, related to another matter that the judge has or has had. Now, why am I telling this super geeky inside baseball about how cases are assigned to judges, and why should any of us care? Well, I'll tell you why this matters. In the 1990s, when the anti-gun industry was ginning up their efforts to destroy the gun industry, because if there's no guns, there's no gun rights, right? You can't buy guns. I know today in the year of our Lord 2023, we can talk about making our own guns, but back in the 1990s, and practically speaking, even though you can make your own guns, it's a lot easier to buy them. I think we can agree on that. Back in the 1990s, that was not an option. So what happened in the Eastern District of New York, and why do you care about the spin of the wheel, the random assignment of judges, and this exception to that? They're related to prior case doctrine. The answer is because there was plaintiffs' lawyers who had sued the gun industry in the 1990s, who wrote down on their piece of paper that their anti-gun attacks on the gun industry were related to a series of products liability cases commenced many, many years before involving a drug. That's right, a pharmaceutical drug called DES. DES, and you're like, oh my God, what are we talking about here? I'm going to tell you. DES was an anti-miscarriage drug that was made by many manufacturers from the time period of like the 1930s through like the early 1970s. And it was a very popular drug. It was prescribed to women who were pregnant to try to help them avoid miscarriages. It turns out, however, after being used for many, many decades, as I understand it, these drugs gave rise to things like birth defects and other terrible ailments to the baby and or to the mom. We don't need to get into those details. The bottom line is it turned out that the DES drug that was prescribed for decades had a lot of bad side effects. So there were a series of products liability lawsuits brought against the various pharmaceutical companies that sold DES. Here was the trick, and here is where it becomes important to the gun industry. What happened was the DES pills, because they were like generic looking pills, they all looked the same. They were all like little white pills or something. They all looked the same, no matter who made them. In other words, one pharmaceutical company made them, they looked little white pills. Another pharmaceutical company made them, they still look like little white pills. The women all took these pills. But when they found out about the problems with DES, many, many, many years had passed since the pregnancies had come to their completion. So when the women and the babies, the children, commenced lawsuits against the pharmaceutical industry, they were not able to establish causation between the drug they took specifically and the pharmaceutical company that sold their specific drug that they ingested, because there was no way to physically tell which pharmaceutical company sold the particular pills that particular woman took. So therefore, the women and the babies who sued the drug companies could not show causation between that particular pharmaceutical company and the injuries associated with a particular woman. So this case long goes to a judge named Jack Weinstein. If you haven't heard the name Jack Weinstein, you'll want to Google it. He is now passed away, but when he was alive, he was considered a radical left-wing judicial activist at the highest levels. His activities would by and large make even the liberals on the Supreme Court in the height of judicial activism blanch. That's how radical left-wing Jack Weinstein is. Even his obituary described him as having an activist streak and playing fast and loose with the various rules. And needless to say, he was a radical liberal. The point is, Jack Weinstein was a very good judge for the anti-gunners to have against the gun industry. And the reason why, in addition to his political viewpoints, is he was also the judge that presided over these DES cases against the pharmaceutical industry many, many years earlier. And what Jack Weinstein figured out, and the way he overcame that tort liability about women not able to connect the dots with the pharmaceutical company and therefore would not be able to sue and collect money from the industry, Jack Weinstein helped with others devise a theory called market share liability, and I'm generalizing here for your purposes. The idea being that if you're a plaintiff woman suing to recover money from the industry, all you need to do is say that you took the drug from the industry, and then Jack Weinstein, would bring the entire pharmaceutical industry, every company that sold DES, into the court, and basically would make a decision as to market share during the relevant time period of the various pharmaceutical companies. So that, let's say there was 5 pharmaceutical companies, one was responsible for 50% of the market and the others for 10% each, whatever it is, do the math, doesn't matter. And you were a woman and you lost $1 million in damages, then Jack Weinstein set it up that the pharmaceutical company that was 50% of the market had to pay you half of that $1 million, and that the other pharmaceutical companies would have to pay their pro rata share of the damages to you, the plaintiff women. So you see how Jack Weinstein worked to get around the basic rules of causation, which is I have to show that Bob hurt me and Bob has to pay me money. Jack Weinstein got around that basic rule by saying that all you need to do is to sue the entire pharmaceutical industry that sold DES as a drug, and then we'll whack up damages based on market share liability of those companies without having to show the basic tort law rule of actual causation between my injury and the particular person that caused it. You see how Jack Weinstein got around that in the DES cases. But DES was a unique situation because all the drugs basically looked the same and were the same, so you can in theory argue conceptually why that might make sense there. Now the reason why I gave you this backstory, and again, you need to know this because if you really want to be the smartest person in the room in the Geeks, you got to know this. So when we go back to 1995, when the anti-gunners and their lawyers filled out the forms, when they sued the gun industry in these very high-profile cases, they wrote down on their lawsuit forms that they gave to the clerk's office that these cases against the gun industry were related to the cases against the pharmaceutical industry in the DES lawsuits. Why? Because the market share liability that was created in the DES cases, because all the pills were the same and they couldn't figure out who took which pill, the argument was that the anti-gun lawsuits wanted to hold responsible the entire gun industry for the various violence associated with the damages associated with gun violence in New York City, and therefore the same legal theory used in DES cases years earlier by Jack Weinstein was related to these lawsuits against the gun industry. So what happened? So that's what these forms were designated. They designated these lawsuits against the gun industry as related to the DES cases. As a result of that related to, guess what happened? These lawsuits against the gun industry were initially assigned by the clerk's office, as protocol dictates, to Jack Weinstein. The anti-gun cases were assigned to Jack Weinstein on the grounds that these were related to the DES cases. And Jack Weinstein agreed. They were related even though they had different defendants, different plaintiffs, different industries, different products, different time periods, and so on and so on. And the fact that, of course, all guns, clearly you know what one manufacturer of a gun is versus another one, unlike the DES case where they're all little white pills. You couldn't distinguish between the two. Totally different. Nevertheless, Jack Weinstein agreed that the gun industry cases were related to these DES pharmaceutical cases. And this is a huge deal because he claimed they were related. He got all these cases. Now, the gun industry, kudos to them, filed a series of motions saying that they had a right to a spin of the wheel. They had a right to file a motion and have a random assignment of judges, as opposed to have the plaintiff's lawyer designate these cases related to Jack Weinstein's cases in the past and Jack Weinstein taking the case. They wanted a random spin of the wheel. But Jack Weinstein issued an order saying, no, he gets to decide what's related to his docket and what's not. He gets to decide. So he says, because they're related, there it goes. Now, there was a second motion filed in front of another judge saying that, look, Jack Weinstein can't make this decision. This is absurd. We, the gun industry, want a spin of the wheel and a random assignment of all the judges in the Eastern District of New York because we don't really think Jack Weinstein is related to this and we don't want him as a judge for a whole host of reasons. Nevertheless, another judge says, you as a litigant are not entitled to a spin of the wheel and random assignment of judges. If Jack Weinstein and the plaintiff's lawyers say it's related, and Jack Weinstein said it was related as a judge, it's related, and guess what? That case against the gun industry went to Jack Weinstein. Now, the consequence of this is I'll give you the bad news and then the great news. The consequence of that is from 1995. I want you to think about this for a moment. From 1995 until 2003, the American gun industry, for all intents and purposes, were subject to discovery and harassment, time-consuming depositions, discovery, and headaches for 8 years, having to spend money on lawyers and time and headaches in all these cases against the gun industry based on being claimed that they overflooded the market. This is basically the theory was that the gun industry overflooded the market. They flooded these markets in the South, and these guns made their way up to New York to gangbangers and other street criminals. And therefore, the damage associated with these street criminals using their firearms illegally should be borne by the gun industry themselves. Now, the good news is, despite spending all this time and money, the anti-gunners lost. Specifically, in 2003, I'll read you an article here. Quote, a federal judge threw out the NAACP's case against the gun industry Monday. U.S. District Court Judge Jack Weinstein ruled that the National Association for the Advancement of Colored People failed to show that its members were uniquely harmed. So in 2003, after all this work and this trials and time, Judge Weinstein did obviously the right thing, which is there's no way to hold liable gun companies responsible for criminal conduct of third parties over whom they've never met or seen. It's ridiculous. It would never be done in any other context in the law of tort. But of course, some judges like Jack Weinstein bent over backwards to try to make this happen because the goal was not to win the cases, in my opinion. It was about imposing cost. Let me give you a couple quotes from 2003, and then I'm going to give you the great news, what ultimately happened. This is from Larry Keane, the General Counsel of the National Shooting Sports Foundation. I think Larry Keane may be the president today of the National Shooting Sports Foundation, but I'm not sure of that. I'm sure you all know Larry Keane because he's in the media quite a bit about these issues. This is what he said back then in 2003, quote, "It's regrettable that the industry ever had to defend itself against such a frivolous lawsuit," close quote. That's what Larry Keane said. But let me tell you what the plaintiff's lawyer who represented the NAACP in this case said. She called the decision a moral victory that could lead to similar lawsuits by the city or the state. In other words, again, it goes back to my point that these cases were being brought not necessarily to win, in my opinion, although if they won, that was gravy, but what they really cared about was making it difficult to do business if you're an American gun industry. So where did all this stuff lead to? Well, we know that in 2005, after the election of George W. Bush and the events of 9/11, people realized that if you want to have a robust, safe marketplace that respects the Second Amendment's right to keep and bear arms, as well as make sure that we are safe from foreign invaders and that we have a robust defense industry, you need guns and ammunition. So because of these lawsuits that had been brought against the gun industry in the late 1990s and the view that these were really goals about imposing costs in the industry. So in 2005, Congress passed the Protection of Lawful Commerce in Arms Act, which basically says that you cannot sue the gun industry or gun company for the criminal acts of third parties, with very few exceptions. This should never really apply for all intents and matters. But nevertheless, this was a law that had to be enacted and did really nothing more than codify black letter common law protecting defendants in tort cases going back hundreds of years. But because these laws had been abused in certain jurisdictions by the anti-gunners, Congress felt the need to act to make sure that the gun industry was protected, because if you don't have a gun industry, we're going to be buying all of our weapons from China and Russia, and that is probably not a good plan. And, of course, we have a Second Amendment right to keep and bear arms, which means we have a right to acquire them, and people have a right to sell them, because there's no way to keep and bear arms unless you first and foremost acquire them. So, the bottom line is that Congress recognized the issues and costs associated with Jack Weinstein being assigned a case as related to a bunch of cases that really had nothing to do with the gun industry. But a single activist judge in the Eastern District of New York, which is Brooklyn, in and of himself, with all of his conduct, ultimately gave rise to the passage of a major law that does help, I think, the gun industry tremendously. And thank God it's out there, although it needs to be robustly enforced more than it has been over the last few years, but that's a different video. So again, this discussion of whether or not the judge in the Donald Trump case, how did he get the case, presumably because the claim is that everything relating to Trump should go to him, gave rise to my memory of this 1990 situation involving the spin of the wheel, a related to case, and the judicial activist liberal Jack Weinstein, and the story of the gun industry being sued, and ultimately the enactment of the 2005 Protection of Lawful Commerce in Arms Act. Okay, folks, I know it's a little bit longer. It's a little bit geeky. I had a lot to cover. I hope you appreciate it. And again, if you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.